This year, the proxy season is going to be very interesting for public companies because as in the last few years, we're going to have a lot of shareholder activism. There's a lot of attention focused on executive compensation and corporate governance. And now we have the Dodd-Frank Act, which was enacted over the summer, which will require all public companies to submit to their shareholders an advisory vote on executive compensation, as well as a vote on how often they should vote on their executive compensation. And this is going to be something new for many companies. It's been tried out, sort of lab tested for companies that received TARP assistance. But for the first time, it's going to be required for all public companies this year. This new advisory vote on executive compensation, which people call say on pay, is effective beginning for meetings occurring on or after January 21st of 2011. And the SEC has now proposed some rules that will essentially implement the provisions of Dodd-Frank that talk about say on pay. Now, even if those rules don't go effective, companies still have to seek this shareholder vote. Companies need to really think closely about their strategy in preparing for the say on pay vote. The say on pay concept came to us from abroad in the United Kingdom. It was introduced in 2002, and the idea behind it was really to encourage shareholder engagement over executive compensation issues. The fact that this vote was going to happen was enough to prompt companies to go out and talk to their institutional investors and find out what concerns they might have with pay programs. This same level of engagement is expected to happen now in the United States as a result of the imposition of a say on pay requirement. And that's one of the first things companies need to do, is identify their largest institutional investors, figure out what sort of concerns and policies they might have about compensation programs, and go out and start talking to them. In addition to that, companies are going to have to focus on their disclosure, because before, companies had largely been thinking about writing their disclosures for the SEC's benefit or for the public's benefit, but really they need to focus on convincing shareholders that they should support this and cast an affirmative vote for the executive compensation program. One of the things the Dodd-Frank Act requires is that not only do you have to get the say on pay vote, which has to happen once every 3 years, but you also have to seek a vote once every 6 years on how often you're going to ask shareholders to vote on pay going forward. And what the SEC has proposed is that that would be cast essentially like a poll. You would ask the shareholders, do you want to vote on the say on pay resolution every 1 year, every 2 years, or every 3 years? And that's what companies are going to have to put in their proxy statements. The SEC hasn't prescribed exactly how you should write that resolution or whether the company needs to make a recommendation, but by and large, I've been advising people the company should make a recommendation as to what frequency they should use. And a lot of factors go into deciding what's the best frequency. Some companies have very long-term compensation programs that work on 2 or 3 year performance cycles, and for them it might make more sense to have a vote every 3 years. Contrast to that, a lot of institutional investors think that shareholders should have a voice every year, and as such, you should have a say on pay vote every year so that the focus can be on the executive compensation disclosure and the pay decisions that are made by the compensation committee. Another aspect of the Dodd-Frank Act was to require a separate vote on golden parachute arrangements. And golden parachute arrangements are essentially arrangements that are triggered by a merger, a disposition, a major transaction. And what the Dodd-Frank Act said is when that merger is put up to a vote of shareholders, the shareholders also should give an advisory vote on the golden parachute compensation itself. Now, they also said that you could put that golden parachute compensation up for a vote under the regular say on pay vote that happens at the annual meeting, and thereby avoid having to put it up later at the time of the merger or other extraordinary transaction. It seems unlikely that people will want to put the golden parachute votes up for a vote on an annual basis and really just wait to see what happens if there's a merger or other transaction. But this is something we'll have to see play out over time. In terms of generating shareholder support for the say on pay vote, I think the keys are engagement with the shareholders, actually talking to them, understanding what they want. And that may not just be with the institutional shareholders. It may be going out and taking a poll of what the retail shareholders are very interested in. It may also be going out and trying to figure out, are there elements of my pay program that when looked at from the outside may be viewed adversely by proxy advisory services such as ISS as well as shareholders. And are there ways I can make adjustments now that will lead to support for the say on pay going forward? And another major consideration is really focusing on the disclosure itself and trying to streamline the disclosure, make it a lot less hard to get through in the proxy statement, which has really been a problem generating over the last few years because people keep adding more and more information. And so people put things like executive summaries in their compensation disclosure to try and really emphasize and ask for support of a say on pay resolution. In terms of trying to interpret the advisory vote on executive compensation that will happen at the company's annual meeting, and then the vote in terms of how often they should vote on that advisory vote on compensation. It's a bit of a blunt instrument, and that's one of the problems I think with the say on pay vote that people struggle with. It's not a line item vote on each executive officer's compensation, nor is it really specific to any elements of compensation as well, whether it be equity awards or cash awards or the like. So when people get a say on pay vote that may be adverse or not strong support, they're going to really have to figure out what was it that caused this problem. In terms of the frequency of the advisory vote on compensation, I think that will be something people will have to work out because it really is a poll. It doesn't necessarily, because there's three choices, it doesn't mean one will get the clear majority. And people are struggling with what would be the best way to interpret that, whether to apply sort of a plurality standard where whatever carries the most votes would indicate to the company what is the appropriate frequency. One question in terms of how these votes will impact director elections is, I think, what will the proxy advisory services like ISS do? And what they've done in the past proxy season is, if a company has a say on pay vote on its ballot, that's the target it'll shoot at. And if it has problems with the company's compensation programs, it'll recommend a vote against the say on pay. And then if that problem isn't remedied the next proxy season, it will shift the focus to the compensation committee, the members of the board that serve on the compensation committee, and seek to withhold votes for those directors as a signal that we're still unhappy with the say on pay vote. And so as a result of all this, I think in some ways say on pay will take the pressure off of compensation committee elections, because there'll be some other mechanism in which shareholders can express concern or displeasure with executive compensation programs. Each proxy season seems to be getting more and more complicated in terms of the new requirements, in terms of what the SEC expects and what shareholders expect. In addition to compensation, people are very much focused on corporate governance and whether a company has implemented majority voting, or whether it still has a classified board, or whether the chairman and CEO are in separate positions or the same individual serving as both. And those situations continue to be hot button issues for shareholders that affect the outcome of votes for many different kinds of proposals.